Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious freedom from the perspective of faith based nonprofits. In today's special episode, we'll talk to one of our country's foremost experts on First Amendment principles, specifically the Church Autonomy Doctrine, and how these principles protect your religious freedom. Dr. Lael Weinberger is a fellow at Stanford University and attorney here in Washington, D.C. Thank you so much for being here, Lyle.
Great to be here. Thanks for having me.
So, for anyone working in a faith based organization, this episode is a must listen. Understanding religious freedom, but particularly the church autonomy doctrine, is crucial. So, stay tuned today. Um, and Dr. Weinberger, what brought us into conversation on these issues was a recent piece you wrote for World Magazine. And I wanted to ask a little about that piece. But before doing so, just ask a little bit about your path into the law. So, can you tell us a little bit of your story and what catalyzed your interest in religious freedom and the church autonomy doctrine specifically?
Yeah. So I first stumbled across this when I was still an undergrad, and I was kind of a history nut, and that's where I nerd out, and I like American political history and legal history, which is what ultimately led me into the practice of law and law school. But one thing that I kind of stumbled across um, while I was an undergrad was this religious liberty case that at the time had just been decided by the Texas Supreme Court. It was a case called Westbrook v. Penley, and it arose from a dispute in a church in Texas where a pastor had been providing counseling to a couple in the church, and the um, Peggy Penley, the one of the recipients of the counseling, um, then had dispute. It became clear that she was involved in a relationship that was not consistent with the ethical standards of the church. And then the pastors and church leadership sought to provide pastoral guidance, counseling. She was not receptive, and it ended up going into a church discipline proceeding where, following the principles in the Gospel of Matthew, the church sought to then um, bring others from the church to seek to encourage this individual to come to repentance. And things progressed from there until finally she was suing the pastoral leadership, saying, "You disclosed information about me from our counseling that I think was in violation of your duties of confidentiality as a counselor, etc." And the church said, as a matter of First Amendment religious liberty principles, you can't have a court coming in and telling a church how they operate their counseling, especially when, I mean, she knew that she's coming to pastors for counseling and advice, and she knew that it's there in the statement of faith and membership principles about dispute resolution, and it points to the passage in the Gospel of Matthew, chapter 18. And so this interesting case progresses through the Texas courts, and the Texas Supreme Court ultimately gets a look at it and says very clearly that the church has this First Amendment protection. And in explaining this, the court described how the church and the state are recognized as having their own spheres of sovereignty. They are to respect, and the courts are to respect the domain of the church. So anyway, I stumbled upon this. I thought, wow, this is not the high profile First Amendment religious liberty stuff that I was most familiar with at the time. This isn't lawsuits about saying under God and the Pledge of Allegiance. This isn't about a Ten Commandments display in a school that or on a government building. This, it was kind of mind blowing to me. Wow, this is really about distinctions between the church and the state. And as someone from a theologically um, Christian perspective. So I was familiar with some church history and some uh, theological conversations. Like, wow, this intersects with all of these things, and so that got my attention, and I've been following it ever since. So that was 2008, and then as I've had various twists and turns in my career, and been to grad school for history and law school, in academia, in practice. I've kept track of these cases, and this area of law about the protections for churches and religious institutions more generally has been one that I've followed ever since. And it's known as the Church Autonomy Doctrine. It's the label that the courts will often put on this particular body of cases. And it has turned out to be a really important one, and a lot of attention has become focused on this now in a way that it wasn't um, 17 years ago when I first stumbled upon this.
Yes, I remember um when the first time I came across the church autonomy doctrine wasn't actually in law school. It was actually when I saw the abstract for the limits of church autonomy doctrine paper that you wrote. I think you were at Harvard at the time, and I thought, oh, church autonomy. And my immediate assumption was very focused on the vocabulary. Oh, this means that churches, a house of worship is autonomous. But it's it's broader than that, right? Can you kind of, in simple terms, define the church autonomy doctrine for, particularly for listeners who perhaps lead ministries but don't have a legal background?
Yeah. So church autonomy protects the internal self governance of religious organizations, protects religious institutions from state control. It ensures that religious organizations can control their own beliefs and their internal affairs, and that the state doesn't tell religious institutions how they run themselves. And so church autonomy is the shorthand that applies more broadly than to just churches. It, of course, applies to synagogues, mosques, also religious schools have been institutions that have been able to invoke this doctrine. But we use the shorthand church autonomy, which is historically certainly the main place that this showed up and then was established in American law. But I think it's generally common um, understanding and fairly intuitive when you say, do you want the state telling a religious body who they can hire as a minister, or endorsing the theological distinctives of one side of a church split, or trying to declare what counts as the true form of the given faith? These are things that in a country that values religious liberty, we want religious individuals and religious institutions to be able to decide these matters and not have the force of the state or of the courts deciding these matters. And so that's the heart of church autonomy. It is about protecting churches, religious institutions from government control over their internal affairs.
That's a great definition, and it really ties into the religious freedom fundamentals. I always think of like one of sort of the fundamental, like you said, intuitive principles of religious freedom is that the response to the question who leads a religious organization needs to be the religious organization. That's sort of 101 what it means to have a country that preserves religious freedom at the individual level but also at the institutional level, which I think is really particularly important in today's world when institutions struggle so much with public trust and even just basic kind of performance metrics. So I have another question. It's kind of two-tiered. I want to ask where the doctrine comes from, but there's sort of two senses in which I'm asking that. The first is building kind of on the fundamentals. The idea of a religious institution being pre-political. I would love to hear a little of your thoughts on that, and particularly why it was so exciting for you when you discovered this in undergrad and saw so many areas of kind of interest and conviction converging for you.
Yeah. So, where does the doctrine come from? So, yeah. So there's kind of the deeper historical answer, and then there's a practical legal answer. So
Yes.
starting with the deeper historical aspect, I've been long interested in church history. I'm a Jewish believer in Jesus, and so understanding the history of the faith has been really important for me as an individual, for my family, for figuring. There's a long history of um, questions and conversations about Jewish relationships with Christianity. So uh, that's neither here nor there, but that's part of what initially drew me into this area of history as an area of great interest. And what specifically caught my attention as I stumbled upon a church autonomy case initially was that the kinds of issues that they were talking about regarding distinctions between the church and the state were issues that would have been recognizable for basically 2,000 years of church history. This question of, do you have the state, the king, the government, the courts, whatever institutional form it takes in a given culture or location, do you have them decide who gets to be a member of the clergy? Do you have them decide what it takes to be a member in good standing of the church? Do they get to kick people out of the church? Um, or is that something that the religious institution as such gets to decide? And in a lot of ways, it felt to me like this was peeling back layers that in the American church state conversation, we often run into people talking about the separation of church and state in a kind of form that makes it sound like you're separating religion from government. And then a lot of folks like us who have been in religious liberty circles, um, one line that we often hear from folks who want to push back and say, no, there is a place for religion in the public square, a place for religion in our society. There's no separation of church and state in the Constitution. Well, at one level, if you're encountering someone who thinks separation of church and state means separation of religion from public life, well, that's certainly not in the Constitution. But at another level, that that way of talking about church state, I think, ends up with a lot of sloppiness about the categories. And then the church autonomy line of cases actually provides this level of clarification that I think is really, really useful, where it directs us back to seeing, okay, there is the state, and it is an institution. It has an important role to play in our society. But there are also the church. There's religious institutions and bodies, and they are not the same as the state, and they have a distinctive role to play. And you think of it this way: that uh, in biblical terms, the church is given symbolically, in the words of Christ, power of the keys of the kingdom, and it has a responsibility for maintaining its integrity. And this has long been understood in church history to give the church the authority um, to exercise a degree of church discipline, exclude individuals from fellowship or from partaking of communion or the Lord's Supper in case of apostasy or serious matters that bring them out of good standing. And meanwhile, the in scriptural terms, the image of the state is the state has symbolically the power of the sword. It has an authority um, to protect public order and to punish wrongdoing. And if the state comes in to say, we can tell you who can take communion and who can't, that is a fundamental interference with the proper authority of the church. If, on the other hand, you have a church that says, we think that the state is handling criminal justice wrong. We're going to set up, a small jail in the church basement, and we're going to, run our own little jury system with church members. That's absurd, and we laugh at the craziness of it. But that would be a similar imposition in the other direction of the church trying to take over what is properly a state uh, area of jurisdiction. And so the church autonomy cases, I think, are the clearest cases that are regularly in the courts right now that get at the core issue in separation of church and state. What is the proper understanding of separation of church and state, and one that can actually be defended in terms of scripture and church history and theology, as well as political theory and legal theory and constitutional law? Well, it is one that recognizes that there are distinct authorities, distinct institutional manifestations that are supposed to be respectful of the proper functioning and role of each other.
It that's really wonderfully put, and I had sort of the same experience when I started learning about church autonomy because for a lot of my study of especially the First Amendment religion clauses, it seemed like the Establishment Clause was limping along a bit, and it was being invoked primarily in cases where everybody gets a playground except for the Christian school, or everybody gets, XYZ, everybody gets FEMA, funding for hurricane relief except for the synagogue that's, assisting with this food bank or something. And so I had seen the development of the Establishment Clauses, um, yeah, like limping along, or just something was seemed very unhealthy about how it was being applied. And then when I began to learn about the Church Autonomy Doctrine, it seemed like this restoration happened, and it was like, oh, that's what this means. There is so much value and clarity and assistance provided when this is rightly understood and isn't understood simply to mean we can't have productive uh, collaborations with religious institutions and the government, which is obviously so wrong, but sort of became uh, a patch, I guess, to
Yeah.
remedy a lack of understanding of healthy church autonomy and that boundary, I guess.
And I think that
So
gets to I think that gets to the other component of um, how you pose that key question of where does the doctrine come from, which is, if you ask the court, you're probably not going to get this a disquisition on 2,000 years of Western political history and so forth. But you will find the also very true answer that church autonomy doctrine derives from both components of the First Amendment's religion clauses. So, as you know, the First Amendment religion there are two religion clauses: one that talks about protecting the free exercise of religion, and the other that prohibits an establishment of religion. And church autonomy actually hits both, because if you have the state telling the church what to do, how to run its affairs, that is both interfering with the free exercise of religion, because the state's telling you what to do. And it's also establishing state guidelines and standards for how religion is to be practiced, how churches are to be operated, how the institutions are to be run. And that, it sounds in an establishment violation. And when you actually see that together, one of the problems in law school is, these are often just taught as, here's our segment on free exercise cases, here's our segment on establishment clause cases, and sometimes these are even thought to be in tension. The Supreme Court in last few years has been very rightly trying to provide some correction to this, which is widespread idea that, too much free exercise starts to invade the establishment clause, and too much establishment clause will um, limit free exercise, and say, actually, these are supposed to work together. And we see this really clearly in the church autonomy cases.
so I think most people haven't really heard necessarily of the church autonomy doctrine outside of the legal profession, but I think the sort of related or derivative doctrine of the ministerial exception has made it more into the public vernacular. Can you touch a little bit on the ministerial exception and then connect the dots between the ministerial exception and the church autonomy doctrine? Again, specifically for people who might be working in ministry and could potentially be protected by some of these, like some of this jurisprudence.
Yeah. The ministerial exception it's really it comes under the umbrella of church autonomy. So if you think of church autonomy, it's the big constitutional principle. And then underneath it, there are applications. And one of these applications comes to the area of employment law. And this is where the ministerial exception comes in. And so it's an exception to regular employment law principles, and it's an exception provided for ministers. So think of it this way. There are a variety of federal anti-discrimination laws. There's the Americans with Disabilities Act, prohibits discrimination on the basis of disabilities. There's age discrimination in employment, uh, that forbids age discrimination. There's Title VII that prohibits employment discrimination based on race, religion, sex, national origin. But imagine then a religious body is applying this and they're setting their hiring criteria such that will not they have religious convictions about particular gender roles for certain positions in the institution, so all male priesthood, or something like that. Are they risking violation of the discrimination laws by creating this kind of criteria around their hiring firing? And the answer is no, because there is this ministerial exception that allows religious bodies uh, a First Amendment protection on their decisions about who they hire and fire in ministerial roles. And the reason for this is a very practical application of these church autonomy principles that we've been talking about. That if the courts could set the criteria by which you decide who serves as a minister, well, that would then involve a judicial interference with the governance of the organization. And it could also involve, in some of these situations, um, judicial entanglement in trying to evaluate, is this religious body, um, what are their beliefs about gender roles, for instance? And this is not really what we want courts to be in the role of deciding. So the ministerial exception then provides this First Amendment protection around religious institutions choosing important faith conveying roles, um, that it goes under the label minister. But of course, in some traditions, uh, that won't be the label that they use, but that kind of conveys the big idea there.
So, if we were to draw almost like a flow chart or a family tree, would you kind of have it that top first tier, the First Amendment itself, and then maybe the second tier would be the ministerial accept, or excuse me, the church autonomy doctrine, and then that third tier would be the ministerial exception? Is that kind
Y-
of how you would
Yeah,
describe the relationship between these three kind of areas?
yeah, totally. I would say that you have to go to the First Amendment that provides the textual basis in our fundamental law and the Constitution, and then church autonomy principles follow as a logical deduction from those First Amendment protections, and then one application of these church autonomy principles comes in church uh, employment decisions, and then you get the ministerial exception. So yeah, I think it is a logical flow chart right there, and each one is a logical inference from the one before.
So, while the ministerial exception might be a bit more familiar to listeners, The church autonomy doctrine goes beyond the hiring and firing decisions into other areas, as you mentioned, of really church governance. And in a sense, I think you could almost say that church autonomy is a faith community's protection or its freedom to be who they are according to their own beliefs. Um, this has come increasingly into kind of headlines with the Huntsman case and the O'Connell case. Can you talk a little bit about those cases? I think they're particularly interesting because they're not the usual fact pattern. So, can you talk a little about the fact pattern and what we can learn and kind of what way the wind is blowing with the church autonomy doctrine right now?
Yeah. So these cases are both very similar. So I'll give the details from the O'Connell case, which is pending right now, and one part of the litigation is in the D.C. Circuit Court of Appeals. Um, so David O'Connell was a parishioner from Rhode Island, and uh, his church took up a collection donation known as Peter's Pence, which is a longstanding charitable collection in the Roman Catholic Church that goes to uh, the Vatican and then is allocated by the Vatican for church use. And um, Mr. O'Connell donated to Peter's Pence at some point, and then later found out that some uses of Peter's Pence went to uh, certain certain uses that he thought weren't sufficiently charitable. So, for instance, should this all go to the poor, or can some of it be used for maybe church renovation work, um, or maintenance for a local church? And this is certainly something that one could debate. What's the wisest use? It's always a question of is this sufficiently forwarding our charitable purpose? And so churches have these kinds of conversations all the time. What the novelty is here, Mr. O'Connell, disagreeing with church leadership's use of the money, brings a lawsuit, and not just on behalf of himself, but on behalf of all church donors, everyone who donated to Peter's Pence. And he sought to use the lawsuit as a way of expressing his dissatisfaction with the uses of the money, and uh, and the claim is really quite astonishing that if he succeeds in this, then he and a whole class action, potentially representing all Americans who donated to Peter's Pence, could then have a court come and look at decisions made by church leadership about how to spend these donations, and then have the court say how much is appropriately spent on maintaining a building versus going to a soup kitchen. And these things can be really complicated. Soup kitchens need a place to operate. Maybe you need to maintain the building for the soup kitchen. Maybe you need to, how you sort all these things out as a court will require an incredible amount of knowledge and information about how the churches are run, what the religious principles are that guide what counts as charitable or not, how it's decided whether to invest in longer term infrastructure that may benefit um, the church, the poor, the community widely, how to invest in shorter term relief. There are a lot of complicated issues here. I think listeners get the picture, and you can just imagine that lots of additional ways if you're involved in leadership for a church or ministry or a nonprofit. There are a lot of issues that come into play, and you can imagine trying to get a court to understand and then think through all of these um, puts the court in an incredibly awkward place with an incredible amount of intrusion into the religious body. So, similar lawsuit was then filed in um, the Huntsman case against the uh, the Mormon Church, the Church of Latter Day Saints, and we have now a few of these cases where plaintiffs' lawyers are trying this really novel and aggressive way of trying to get money out of religious institutions. And I think this creates massive church autonomy problems. Should probably be obvious based on the stuff we've already said, that this is entanglement. This poses risks of church interfering both with the free exercise decisions of the religious body and also setting its own standards and therefore creating an establishment of religion, telling churches, religious bodies how they should operate. So I think these are very concerning. Um, and the there are some technical issues with exactly how the litigation is proceeded. Uh, I'm I'm pretty confident that in the long run, the courts will see the way that this interferes with church autonomy. Um, what I'm hopeful for instance, in the DC case, the O'Connell case, uh, I'm hoping that the court would recognize at the very outset the risks that this poses, and therefore, for First Amendment reasons, um, dismiss the case at an early stage. And if they let the case go on, it's not that all is lost, but there are real burdens that that will impose, and I think real First Amendment violations that will occur in the course of the litigation. And that right now is what we're waiting on to see how aware the DC court is of those risks. And at this point, what I would see as a disappointing result is forcing the church to go through a kind of drawn out litigation process in order to uh, prove with painful detail how intrusive this litigation is on its internal affairs.
I can totally see how, even just the discovery and even in the trial stage, you already have churches sort of um, basically being audited by the government about decisions that they're making that are very, as you said, intrinsically related to the church's own view of itself and its mission. So,
Yeah.
certainly, establishment clause, red zone or danger zone there.
Yeah.
Um,
And full
I,
disclosure, so
yeah,
I filed a brief in support of the Conference of Catholic Bishops in the DC case. And one of the things that I tried to point out in this brief is the ways that this has worked in some other cases, where again, some of this is in the weeds of the civil procedure and the what precise point in the case does the court make the decision. Um, but the big picture here is just to show that there have been a few cases where people have tried to extract money or various using litigation against religious bodies, and where the courts have let this go far into the discovery area, where people are um, taking depositions of church leadership and so forth. This has been really not good for the religious bodies or for the courts trying to referee these kinds of disputes, and trying to put the brakes on at an earlier point before this goes far down the road of litigation is really in the interests uh, of the courts and of religious liberty.
yes, it's amazing to see how what kind of when you first started writing about this was almost an academic kind of free for First Amendment doctrine, something for scholarship, and now we're just seeing these deeply practical implications for religious groups that are just what this looks like when it's violated. Can you just to close us off on that practical note, for those of our listeners who are in ministries or religious communities or religious organizations, can you give a few practical tips? Like, for example, how do they opt in to the Church Autonomy Doctrine? Do they fill out a form? Do they apply to churchautonomydoctrine.com? Or how do people I don't want to say take advantage of, but how do people um participate in these protections that our founders established in the Constitution?
Yeah. Well, there are no magic words and there are no forms to be filled out. This isn't like a tax exemption. and there's not an IRS agency to review. But I think if you're if you're involved in a religious organization and you want to be wise about how you run your organization so that you minimize rather than maximize your liability exposure, one of the best things you can do is have a lot of clarity up front about your religious organization's character, its mission, what you're trying to do. And one of the worst things you can do is to make it up as you go along. And I think this is something that often for smaller ministries or uh, smaller organizations that are just getting going, this is a harder lift because it does put some pressure on, and it's easy to just say like, okay, well, you know, we're forming a ministry to help the needy in our community. So maybe we'll file the articles of incorporation, and phew, we're done with the legal stuff now. And now let's get to the business of trying to help people, which is a good instinct. But what you don't want to find yourself doing is in a situation where may it not come to this, but if one encounters um, employment issues and one has to make a tough decision about a hiring or a firing, uh, you don't ideally you would like to be in a place where you have clarity in your employment documents that this is a person who's advancing our religious mission, and where you explain how that's done. So if someone is um, the receptionist at a local food bank, but it's a ministry food bank. And this person is someone who part of what they do is they pray with people who come through, and they seek to provide some counsel and guidance uh, from a Christian perspective. Well, you want to make it easy in the situation where people are saying, you can't be picky and you can't apply your religious principles and who you're hiring for this role. And if the court says, well, maybe this person is, it can't be that much of a religious role. They're not preaching. Um, they're they're just doing a very mechanical um, administrative role. Well, you want to provide clarity. You want to think through what is this role? What is this person doing? And if there is this kind of potential for dispute, litigation, you want to be able to say, we already have it written out. We have it in our employee guidebook. We have it in, and we refer people to this when we, advertise for the job that explains these religious functions that this person partakes in. Because what the courts are really doing when they're looking at something like the ministerial exception, it's not about magic words because different religious traditions, they might talk about rabbis, they might talk about ministers, they might talk about priests, etc. The terminology varies, but the courts are really trying to figure out what's the function here, and is this really about religion? And is this the kind of thing that we'd be interfering with religious exercise and establishment if we got involved in telling them how to run their affairs? So, best thing you can do, talk, communicate, write stuff down, and be very clear. People know what they're getting involved in, and that will make for a better mission aligned organization. And it will also help if, and hopefully you won't ever have to use it, but if there were to be a legal issue that comes up, that helps make the court's jobs easier rather than harder, and makes it more likely that you as an organization have legal clarity rather than a long drawn out litigation.
Thank you so much, Dr. Weinberger. Where can our listeners learn more about your work and follow some of your scholarship on these issues?
Yeah, well, so if you just look up my account on X, formerly known as Twitter, it's just my handle is just my name, Lael Weinberger, uh, Lael, designed to confuse almost. But yeah, just look up my name and you'll find me there. So I usually, when I'm writing uh, op-eds or academic articles, I'll post the links there. I'm not the most active user, but that is where I collect my links.
Awesome. Well, thank you so much for your time, Lyle, and thank you, our listeners, for joining this special episode of the Napa Legal Weekly podcast. We will talk to you next week. May God bless you.